A new law, effective January 1st, 2021 in California, set forth in AB 685, requires employers to provide notices to employees and their local health department for outbreaks of COVID-19 in the workplace. Hello, I'm Anthony Zaller, and I'm here with Mike Thompson today. We wanted to briefly discuss AB 685 and the new reporting requirements for California employers starting here January 1st, 2021. The new law requires that employers provide a written notice to all employees and their subcontracted employees who are on the premise at a certain time if they're a qualifying individual within an infectious period that they've been exposed to COVID-19. Now, I've got a lot of terms in there, and the law defines those terms, and we'll talk about that here today. The first key term that we want to discuss is the infectious period. What does that mean? And we've gotten some guidance from the state health department about the infectious period. This is defined as, there's two different definitions. The first one is for an individual who develops symptoms of COVID-19. The infectious period begins 2 days before they first develop symptoms, and the infectious period ends when the following criteria are met. 10 days have passed since the symptoms first appeared, and at least 24 hours have passed with no fever, without the use of fever-reducing medications, and other symptoms have improved. Now, the other definition is for an individual who tests positive but never develops any symptoms. The infectious period for these individuals begins 2 days before the specimen for their first positive COVID-19 test was collected, and the infectious period ends 10 days after the specimen for their first positive COVID-19 test was collected. Now, also another key definition here is a qualifying individual. Mike, I'll pass that over to you.
Yeah, thanks, Anthony. So, as you explained, this new AB 685 requires employers to give certain information when there's been a qualifying individual in the workplace. And the statute defines qualifying individuals as one of four things. One, that the individual tested positive for COVID-19 through a laboratory confirmed test. Number two is that they had a positive COVID-19 diagnosis from a licensed health practitioner. Number three is they were ordered to isolate by a public health official related to COVID-19. And then fourth would be if the individual died due to COVID-19. And employers want to keep in mind that qualifying individuals could be other employees, but it could also be customers, anyone that comes into the workplace and meets that definition. Now, comes into the workplace, work site also has is defined in the statute as the building, store, facility, or agricultural field where the worker worked during the infectious period. So if the employer has multiple buildings or multiple floors, the zone that qualifies for giving notice to employees is the work site where the qualifying individual actually visited. So that specific floor or that specific building. Now, Anthony, what kind of information do you have to give your employees and when?
Yeah, so there's some best practices on that. It has to be a written notice to the extent there is an exposure that meets these definitions in the workplace. The employer has to provide written notice to the employees within 1 day of their exposure of the probable or confirmed case of COVID-19. So it's recommended that employers start working on that notice, given the short turnaround to provide that notice to employees. And also, if a majority of your employees speak a language other than English, it needs to be translated, and it can be communicated to the employees through written posters or through electronic email postings through the internet, things like that, that you normally use to notify employees of company news. Now, also, we want to talk about the other requirement, the reporting requirement on employers created by AB 685. And employers have to notify their local public health agency of any outbreaks in the workplace. And the term outbreak for AB 685 is defined as at least 3 probable or confirmed COVID-19 cases within a 14-day period of people who work together that aren't in a similar household. So if they come into work, separate households, and they have work closely together, within that 14-day period, if there's 3 or more probable or confirmed cases, that's an outbreak, and the employer needs to notify their local public health agency of that outbreak. Now, coming into the beginning of the year, any other recommendations that we have for employers in terms of AB 685?
Well, I think the most important thing that you mentioned was they need to prepare now, because you have a very short turnaround period. 1 business day after you learn of it, you have to provide the notice to employees, and you have to provide a lot of information. You have to let them know what benefits they're entitled to under the applicable laws, workers' compensation, and then potential leave and sick pay that they may be entitled to. So it's not something that you're going to have to try to put together on that quick turnaround, especially if you're probably in that situation dealing with kind of a crisis at your business. So you want to get that ready now so that you have it ready to go if the need arises. You also want to make sure that you get the information that you need. So say an employee calls you up and said that they tested positive for COVID-19. Well, under the definition of infectious period, you need to know when they started getting the symptoms or when they took the test. So you want to make sure that you understand what information you need to collect so you can make the determination as to when the infectious period is and who you might have to give notice to.
Yep.
Always remember, with giving these notices related to employees, whether under AB 685 or just under your other policy or anything else, you don't want to disclose the employee's name to the other employees, because that is protected information and they do have confidentiality rights.
Yep. And also, I want to point out, too, to the extent you're a larger employer and you've got a larger work site with different buildings or different floors and employees going between the floors, it could be beneficial to have a record of where the employees went with the contact tracing. So if you could limit, and an employee who tests positive for COVID-19, where they've gone. You don't necessarily have to give notice to employees in a different building or close down that other building potentially. So that contact tracing could save you in the long run if you are tracking where employees are. And it's tricky because you won't know 2 days after the fact.
Right.
You might have to go back 2 days from when you discover they tested positive for COVID and know where they've been, who they've had contact with. So it's something to think about, how you can track that and go back in time.
Right. So what you want to think about that now and kind of game out how that might look so that you're not caught by surprise when the need arises.
Yep.
And then, as always, don't retaliate against employees for reporting COVID-19 or anything like that. The law specifically forbids that.
Yep. So we'll have some links below. We've got the California Department of Public Health. They came out with some definitions, these definitions about AB 685 here in October of 2020. We'll link to those definitions.
And as always, if you have any questions or comments, please leave them below in the comments and make sure to smash that subscribe button.